Alex here with part 149 of the My Docket series on child custody and visitation. As for my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go into the Discovery Commissioner's recommendation for order. Now, I remember mentioning this in the previous video. It's kind of surprising that it popped up later on, but I'm kind of recalling now that these documents had some kind of a delay when they were filed by the Discovery Commissioner. It wasn't immediately after the hearing or during the hearing. It seemed like it took a few days or maybe even a week. So that's probably why my attorney was able to take action even though the recommendation for order hadn't been entered yet. And by that, I mean, I think she set the hearing for the actual evidentiary hearing. So in any event, if you want to learn more about recommendations for orders, or more specifically, how to challenge them, please take a look at the video Objection to Master's Recommendation. If you want to learn more about the Discovery Commissioner and the hearing masters that enter them, I have two separate videos. One is titled Discovery Commissioners, and one is titled Hearing Masters. Recommendations for orders are not orders. These are judicial officers that preside over cases that enter recommendations for an order. Ultimately, the district judge has to approve it. So at this point in time, it's just a recommendation for an order. This is, if I remember correctly, an order or an issue that I won on. It's the, or largely won on. I think there was like one thing that he denied, but it basically involved me trying to get access to those CPS records. So let's go ahead and just jump into it. Here we have the Discovery Commissioner's recommendation for order. The standard introductory paragraph, actually, I think he breaks this down into separate paragraphs because I don't see any mention of my ex's filings. So in the first paragraph, he mentions my motion for leave of the court allowing limited discovery, specifically that I am basing my request on multiple reports filed with the CPS agency and an email that my ex sent to the teacher. Next paragraph, he mentions my ex's opposition to motion, where she's basically saying that since CPS didn't want to investigate any further, I had no basis to make this request to this court. Now, let's wait a minute. The third paragraph, he is mentioning my reply to opposition, where I am challenging whether or not the determination made by CPS has any preclusive effect. He next mentions the court's order pertaining to the pending motion to modify child custody, and he points out the fact that the judge wants to wait to see what the Discovery Commissioner does before proceeding on that motion. Prior to the entry of the decree, in this case we didn't have a decree, we had a judgment. It's not we weren't married, so we didn't have a divorce decree. But anyway, he mentions NRCP 16.2 and NRCP 26, which discuss discovery in the general sense, and also the limits on post-judgment discovery in domestic relations matters. He's mentioning that I am not seeking broad discovery and that I am only seeking limited discovery at this time. Here he is contrasting two laws. He's contrasting the law that governs how CPS investigations are to be conducted, and also the law on the best interest of the child factors. In the next paragraph, he points out pretty intelligently that circumstances that don't warrant further investigation as a possible abuse or neglect of a child might, nevertheless, be relevant to the court's determination under the best interest of the child. And he points out an example. This is one of the things that I used. The court observes that the information maintained by CPS, including reports, is deemed confidential, and he cites the law, but then he also goes into the law pointing out the exceptions. And one of those exceptions is that I can force this documentation to be produced before this judge in this child custody case. Under the circumstances, he believes that the appropriate course is to allow me to conduct the discovery that I am requesting, with one exception. In that exception, he mentions 2 paragraphs later, right down here. He does not think that at this time I should be getting any permission to conduct discovery on potential witnesses. What I assume he means by this is that if I do find any other potential witnesses, once I get their identities, I should come back and ask for permission to serve those witnesses as well. This never ends up happening. We don't end up needing to do this. So he ends up concluding that the motion should be granted in part and denied in part. The subpoenas that I want to issue to CPS and the teacher are allowed, and the, I guess you could call it speculative subpoenas that might need to be issued, he wants denied at this time, but I can come back later and ask if I need to do that. Certificate of service under Rule 5 indicating that this document was served to both my ex, her through the mail, and my attorney electronically. Notice to set. This is a document that we have gone over quite a few at this point in time. If you want to learn more about the notice to set, please watch my video on the topic notice to set. This is the attorney indicating that she is going to appear at a specific date and time to determine what date to hold the actual hearing on. This is a setting. This is not a hearing date. This is a setting date. Certificate of service under Rule 5 indicating that this document was mailed to my ex. Here we have the notice of hearing. This is what you see after the setting. After they have decided the date and time of the hearing, this is what happens. And this is what my attorney filed. It's a notice of hearing letting my ex know the specific date and time of the actual hearing. And this is a certificate of service under Rule 5 again, indicating that this document was mailed to my ex. This is a confirming order here. This is what is entered after your opponent does not object to master's recommendation. Because my ex did not file an objection to the master's recommendation within 10 days, this recommendation becomes an order of the court. And that's what the judge is entering right now. He's confirming that that recommendation is now an order effective immediately. And if you want to know more about how to object to a master's recommendations, please watch my video on the topic objections to master's recommendations. Next page is a certificate of service indicating that this document was mailed to my ex and served electronically upon my attorney. Subpoena ducis tecum, this is indicating, or this is sent to the teacher, commanding her to turn over the email that my ex had sent to her on hitting my son with a plastic spatula. Apparently that's what she admits to anyway. Next we have the instructions of the subpoena. And then last, we should have the affidavit of service of the subpoena. To learn more about why those other 2 components are very important, please watch my video, Subpoenas. I'm not going to repeat it because I actually have dedicated a video to the topic, but it's a very important video, guys. We have another subpoena, but this subpoena is targeting CPS, Washoe County CPS, rather than the teacher. And this is ordering CPS to turn over those reports. The rest of the subpoena is the same as the last one, instructions, and again, the affidavit of service on the bottom. This is an ex parte, I don't know why she calls it a request. Ex parte request, motion, whatever you want to call it. She is asking the court to consolidate the upcoming hearing dates. We have 2 hearings that are coming up, August 13th and August 27th. And she wants to blob these together into a single hearing. Most of the first few paragraphs just go into some procedural history of the case. It's pretty mundane. It's just dates and times and the fact that we have 2 issues coming before the court. This part here is pretty important. This is the rule she cites to actually get the court to consolidate the hearings. It's local Rule 42. So the Nevada Rules of Civil Procedure has a rule called Rule 42, and under this rule, you can ask the court to consolidate a couple of hearings if the issues are all related in some way, or if you can actually use a consolidation to avoid unnecessary costs or delay. She then goes into a local rule on ex parte relief. This is a local Rule 43, and these are the points that you can use to try and get ex parte relief. I have a video on this topic. It's called Ex Parte Perils. Usually it fails. But in this case, she's using my ex's email against her. She's filing the email as an exhibit to this document, and that is basically her basis for getting ex parte relief. She's saying, hey, you know what? His ex agreed to it anyway. She hasn't come to the office to sign some documents, but at the very least, we have this email from her. Here we have the conclusion. Certificate of service under Rule 5 indicating this document was mailed to my ex. And then here's the index of exhibits. I wonder if I'm missing this. I don't remember putting an exhibit in here. This is a family court motion opposition notice. This is indicating that I didn't have to file or didn't have to pay a filing fee to file this ex parte motion. So the exhibit is missing, guys. After this video is done, I'm going to go and try and find it. I'll track it down, download it. If I find it, I'm going to go ahead and attach it to this document and then send it in. That way, if you guys want to see it, you can just go into the link into the description below and click on the link, download it for yourself, take a look, and you should be able to see that that exhibit in there. If it's not there, just assume that I tried to find it and I couldn't find it, which would be odd. It should be there. Request for submission. This is indicating that the ex parte motion is being submitted to the court for a decision. If you want to learn more about the request for submission, please watch my video on the topic. It is titled Request for Submission. Certificate of service under Rule 5, again, indicating this document was mailed to my ex. We have another request for submission. This is the one that the court asked us to file after the discovery commissioner finally made a decision on that order, on that motion. He finally made a decision, so the attorney is going in and she is filing this request for submission to let this judge know that that issue is once again ripe for review. And again, guys, good idea to watch the video, request for submission. Another certificate of service under Rule 5, indicating that this one was also mailed to my ex. This is an order of recusal that we've already gone over. It is a copy-paste of the previous order of recusal entered in the other case. That's the writ petition case. The only thing that might be different is at the very bottom, he's probably going to say something like, I vacate the hearings and the new judge can take over and set new hearing dates. That's the only difference. As with my previous videos in my docket series, I do not go over documents repeatedly. If you want to see this document and you want to see my commentary on the document, you can go and, gosh, I don't even know when I went over it. It's probably like 5 or 6 videos ago that I went over this in the other case. I also, as I mentioned earlier in this video, I also include these down in the description below, so you can go down into the description, click on the link, download it for yourself, take a look. And again, guys, if you have any questions on this document, you can always post it down in the description below and I'll answer to the best of my ability. Lastly, we have a case assignment notification indicating that this document has been transferred to District Judge Bridget Robb, who will be taking over on this case. District Judge Chuck Weller is no longer presiding over any of my cases. Going into the aftermath, I filed quite a few documents. Looks like one, or at least my attorney did, 2 documents, 3, 4, 5, 6 documents. It looks like those were, oh no, 7 documents. Those were all free filings. However, usually you'd pay if it was a subpoena for a witness to appear and testify, but those 2 witnesses of those 7 documents, or sorry, those 2 subpoenas of those 7 documents were for the production of paperwork and stuff like that. And so those are going to be free filings under these circumstances. They will sometimes charge you depending on if they have like a policy to charge you or if there's just a whole lot of copies that have to be printed out. But under these, with these 2 specific requests, under these circumstances, it wasn't really very much, so I didn't get charged. So $0 in costs for me. My ex didn't file anything, so she has $0 in costs as well. My attorney would have charged, let's see here, to review the recommendation for order, probably 15 minutes. It's a somewhat lengthy document, but it is straightforward as well. Both the notice to set and the notice of hearing, I'm going to say 5 minutes. No, I'm going to say 15 minutes for the notice of hearing, which is going to take us up to 30 minutes. And then the notice to set, I'm going to say another 15 minutes because she's going to even have to appear telephonically and coordinate with my ex on setting that hearing. So that's another 15. We're at 45 minutes right there. The confirming order, 0. I think both subpoenas, it's going to be an hour. I think 30 minutes each is pretty reasonable because my attorney's preparing them and she has to do her due diligence. So we're at an hour and 45 minutes. The ex parte request, she put a lot of work into it. I mean, a lot more work than I thought she would have. I thought it would have been one of those sort of boilerplate copy paste, but when I read it, I mean, it did seem somewhat customized to my case. I'm going to say 30 minutes again, and we were at an hour 45, so now we're at 2 hours 15 minutes. Both requests for submission, I'm going to say 5 minutes each, which is going to take us to 2 hours 25 minutes. The order of recusal, I'm going to say 5 minutes, which is going to take us to 2 hours 30 minutes. And case assignment notification is negligible. So I think 2.5 hours for my attorney to prepare and or review all of these documents is pretty reasonable. At the rate of $500 an hour, that's going to come to $1,250 in attorney fees. My ex didn't have an attorney, so she incurred $0 in attorney fees. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.